most complicated phase involving last-minute adjustments, managing contracts, finalizing claims, and whatnot. In fact, studies show that approximately 30 to 40% of the project end up in dispute when they are 90 to 95% project complete. Now that's a big number. To discuss as to how to master this final step, we have a distinguished panel with us. It's a mix of lawyers, general counsel, and experts. So just to introduce the speakers, on my right, I have Julian. Julian is partner in London office of Jones Day. He advises on international construction and infrastructure projects across industries such as transport, oil and gas, power, and petrochemicals. Julian has represented governments, developers, and contractors in large-scale construction and engineering disputes. Next, we have James. James is a King's Counsel. He's a barrister at Edkin Chambers. He again specializes in a lot of things: construction, energy, IT disputes, both domestically and internationally. He regularly appears as an advocate in English courts and in international arbitration across the Middle East, Africa, and Asia. Again, James has significant experience in arbitration under all major institutional rules and ad hoc references. Next up, we have Ibars. Ibars is the general counsel that we have today. He's working at Gamma Energy, overseeing power, water, infrastructure projects in Turkey and region. He joined the company in 2012 as the first legal counsel and is a board member of the group company since 2019. Ibars has built a compliance mechanism and played a key role in significant transactions, including multi-million-dollar acquisitions. On my left, I have Khushbu. Khushbu is a senior counsel at Al Tamimi Company with extensive experience in arbitration across civil and common law jurisdictions. She specializes in construction disputes, in international arbitrations under major institutional rules. She has also been appointed as both sole and party nominated arbitrator in various commercial and construction disputes. Next up, we have Adarsh. It's a big panel. Adarsh is a partner at MRP Advisory, based out of Dubai. Most of his experience lies in construction and infrastructure sector. He has advised and represented clients in arbitration arising out of contracts executed in UK, Switzerland, Jordan, Greece, Syria, Singapore, and India. Adarsh has also represented clients before the Apex Court of India, that is the Supreme Court. Last but not the least, we have our expert before us with us. He's Mayank Thakur. Mayank is a senior partner at Messin with over 20 years of experience in delay and quantum analysis, dispute resolution, and arbitration. He has served as claim analyst on numerous construction projects and testified as expert in quantum and delay matters. Now let's deep dive into a discussion on how to successfully cross the finish line of construction project and avoid last minute complications. Now what I have done is we have divided this whole discussion into two segments. The first segment will be a general broader discussion where we are going to discuss generally what the challenges are, and then thereafter we have a small second segment where we'll discuss a case study and we'll seek answers from the panelists as to how to cross the last step. So I start with segment one. I start with Khushbu first, ladies first. What are the most common legal challenges, Khushbu, or disputes that arise in the final stages of construction project?
Thank you so much, Himanshu, and thank you to all of you for attending Mason's fabulous event this afternoon. In his introduction, Himanshu called this topic interesting. I leave it to others to agree or not, but what I can say, the final stretch, and this topic is called Mastering the Last Step to Project Completion. For most dispute lawyers and for most claim consultants, that's actually the first step to a dispute, and that's the first step that we get involved. So it's quite ironic in that sense that when we are acting for a client, we come in, it's our first stage, but for them, they're already to the point of frustration and exhausted with having dealt with the counterparty in their project at that stage. So most disputes, for logical reasons, will start to crystallize in the final stages of a construction project. And this is mainly because it's at that stage where the returns would have been recovered, or the outstanding payments would have become so critically due that now is the time they don't see any need to maintain decorum or diplomacy in engagements and relationships. So that's really the classic point where we come in as dispute lawyers or where claim consultants come in to help with preparing the claims, and that's when the aggressive letters really, you can see, start to accelerate. But some of the disputes, just broadly, which we see at that stage would be agreeing on final accounts, and that's a big one because that's the point where parties are really eager just to get the outstanding payments agreed with, to get to the point of signing. Variation claims, if there's contra charges, it could be reasonableness of contra charges, whether they are substantiated. So all of that I would put under the broad umbrella of just agreeing on final accounts. And then there's a little bit of acceleration, thickening if works had to be mobilized a little bit earlier, a little bit faster, whether those could be agreed as well in terms of cost. That would be the second big item that comes in at the last final stages of the project. And then we come to the point of practical completion now, and that's when, let's say, handover documentation takes a protracted amount of time. Can we get practical completion? Now, a lot of times this depends on the contract, but in civil law jurisdictions, and I think that's one of the beauties of this region, is that deemed handover could be taking place under the civil laws if works were completed and handed over, put at the disposal of the employer or the contractor, depending on the party you are working on. And that what this does is circumvent the whole issue of the documentation stages. And that's what stops also the imposition of the LDs. And that can be critical. And I'll give you an example of a hearing I just finished of a solar power plant in the region. Works were completed, but the final handover documentation took a year and a half because it was such a complex and mega project that it could seem like trifling issues like bookmarking and hyperlinking, but in a project where you have more than 20 different stakeholders, you have governments involved, this leads to complications and this leads to really heated debates as to whether a single piece of document can or cannot be found. So that whole period of the final handover documentation took a year and a half, which was a really long period in the grand scheme of things. But because we argued that practical completion had reached the point before the final handover documentation was submitted, we stopped the imposition of LDs and a lot of the legal and contractual impact also, we stopped the bleeding, so to speak. So I think the big ticket item, the third one, I would say practical completion versus final completion.
Thank you, Khushbu. It is indeed one of the pain areas, practical completion versus final completion. And to deep dive into this, I mean, I would want to get some advice on common law from Julian and James. I'll start with Julian. Julian, in context of common law, how are practical and final completion typically interpreted?
Thank you. Well, if you look at things from a common law perspective, the starting point really is that the common law says nothing about practical completion and final completion. These are concepts that are derived entirely from construction and engineering contracts. So there is no common law relating to practical completion and final completion as such. Therefore, we need to get into the contracts and see what they say in relation to practical completion and final completion. And I think what we find, particularly in relation to both actually, practical and final completion, is we have degrees of vagueness, lack of precision on the one hand, and then we've got highly prescriptive definitions of completion. So just taking the former case, where you have imprecision. An example of that is under the major English form of construction contract. It's the JCT form. And it actually doesn't define what practical completion is, which is surprising. I think it's such an important idea. Why is it not set out in the contract? But the way it's being interpreted is essentially that it's a situation where the employer can take over the work and use the work, and it will function in its intended way. But that's a strange sort of a position, really. Why wouldn't you have a clear definition for practical completion? Whereas at the other end of the spectrum, what you find these days, particularly in a lot of contracts, EPC contracts in particular, is a very prescriptive definition of completion, and that could be practical completion, mechanical completion, or something like that. And not only will it say in the contract that the works must be complete, they must work in their intended way, but you can have all these add-ons as well, saying, yes, the thing has to work. Oh, and you have to provide us with all these other things, as-built drawings, documents, etc. And only when those documents, those additional things are provided, will completion be achieved. I think that's an area where we see a lot of dispute because people often forget about it. So they think practical completion means I've built it, it works, done. No, it doesn't mean that if the contract says something a bit different. And James, do you have further views?
No, I want to agree with that entirely. And what's interesting, of course, is we're using the word practical completion, but a review of any of the sort of main forms we use in the UK, but also across the globe, you see just different terms being used. Practical completion, as Julian says, is a term, probably half a term used in JCT. You can compare numerous other English or UK forms and international forms, and you'll see different words being used to mean broadly the same sort of thing. As Julian says, actually, this is really a contractual concept, one which one of the courts in England and Wales, for example, tried to provide some guidance on what is meant by reference to particular forms, practical completion being, as Julian says, the most usual shorthands being used. And as Julian said, the guidance one gets from situations in which the contract itself doesn't tell you what you need to do is broadly, can the employer take the works into use? If there are defects, non-latent defects or patent defects, are they not such as to prevent use? The word trifling, I think, or push being used, a word that comes up in the latest court appeal judgments. You're looking for non-trifling or only trifling issues that don't affect positive, beneficial use of whatever the building or the process or whatever plant you're after. And that is a concept of which, again, translates well across other forms. We're not using practical completion, but substantial completion, just the word completion, if the contract doesn't tell you more. But actually, as John said, what we're used to is in the PDPC contract, a very prescriptive way of dealing with it. Even in FIDIC, for example, there are other prescriptions, there are tests on completion to pass, all these things, other means by which you can, at least in principle, objectively see whether or not the client has got what it paid for.
Thank you, James. Just a follow-up question. How do these concepts, i.e. practical and final completion, influence claims related to delays and LD during the final phase?
As we all know, practical completion or completion, or whichever term you want to use, is in every contract the end point for the calculation of liabilities for contractual liquidated damages. So the key point is to find that completion point and prove you're complete. So as I think Kushbu said, the sort of leading, if you like, from an attractive perspective of money going out at least up to the cap you've got of uncapped LD. So that's key in that sense. What it doesn't do though is help you very much with what the actually sometimes, which is not an important part of it, which is the accounting process that comes post-completion. As you know, practical completion leads to a point where takeover, completion, use occurs, LDs stop. But you're in then a period of defects notification, defects liability, putting things right. Contractors still on site, incurring costs, dealing with often rather chaotic snagging and defects lists that are coming often thick and fast from the engineer or the project manager to deal with in a short space of time, incurring the cost of doing so at the same time as trying to deal with the accounts, which is really good variations and extra overs, additionals, deductions to be made as well. So actually, although in a sense the build is or should be finished by completion, a lot of the commercials are really in that period, and just as important to achieving a successful in terms of profitable commercial endpoint to the contract is getting to final account and final completion.
Julian, would you like to add something?
Look, only to this extent that if we're looking at the situation as practical completion and the types of issues that there might be, I think you will almost always find issues about money, variations, etc., claims that were made for payments under the contract. But I think, and maybe I sense this is part of the focus of today, there could actually be also a major issue about whether practical completion has been achieved at all. And that itself, it could be a major dispute, which, at least in my experience, is very difficult to resolve at the time. Almost always necessitates some kind of dispute resolution which might happen months or even years later, to determine when practical completion is achieved. So I think if we're thinking about the finishing line and getting over the finishing line, I think that could be one of the major issues in relation to that.
Thank you. We move to civil law now. Khushbu, I think you have touched upon it. That there is, I think, is it fair to say that there is no stricter adherence to finality before recognizing project completion?
Yeah, I think Julian already kind of answered that question really. It's sort of that question where you work backwards, and then when you're in a dispute, everyone's sort of fighting about the point of time when the works were actually executed. But I think a way to go around it is to look at it from the opposite spectrum. If there were any apparent effects which made the works unsuitable for being occupied or not to be used for its intended purpose, then the other side has a ground to reject the works, and that's a valid ground that has merit. So that's really the argument we always see, and that's probably a better and more practical way of looking at the whole issue. And again, I go back to civil law because that's really most of the government contracts in the region are governed by these civil code laws, even though the parties might not even be based here. So that's really the starting point for me. So where there's a defect or breach that has not rendered the work unfit for use, then under the civil law, the employer or contractor cannot reject taking over the work. So practical completion will still be on that date where it's sort of handed over, deemed handed over. But the employer or the contractor has a ground to make a claim for damages due to the breach caused by the defective work. So they can request either a sum that's commensurate to the defective works, or alternative, if they don't want the damages, what they can do is request for the contractor to repair or remedy these defective works, as long as two criteria are met. First, that it's reasonable for the contractor to do so, and secondly, if the contractor can do it in a reasonable period of time. But again, where you see the word reasonable, that's again scope for disagreement and more debate and a perfection of issues in an arbitration.
Thank you. Adarsh, you have been working in UAE. How are disputes surrounding practical completion versus final completion usually resolved? That's A part of the question. And part B is that could you provide some insights on the interplay between legal interpretation and contract terms?
Thank you, Himanshu. So the first question, how disputes are resolved? Well, most parties prefer negotiation. They try to engage with the other party, their counterparty. They try to get the senior management involved. They try to arrange meetings between the highest levels of the company so that they try to resolve it without having to go to the dispute resolution process. But if they have to, then several contracts provide for dispute resolution methods. Arbitration is certainly the most popular mode to resolve disputes, especially in mid and large size projects. Of course, there are other ways as well. There are DABs. There's mode where you can involve experts for an expert determination, or you can opt for something more institutional like mediation. And apart from arbitration, if of course there's no arbitration clause mentioned, then parties resolve these disputes by going to the court. And in the UAE and several GCC nations, there are both offshore and onshore courts, and it depends on which sort of jurisdiction clause stipulates which court has the exclusive jurisdiction. The second question, the interplay between legal and contractual terms. Well, in most in most nations which have civil codes, there are several stipulations and provisions in the civil code which have a variation of a pacta sunt servanda, where parties are required to comply with the terms of the contract that's binding on them, and parties are mandated to comply with their obligations. So most of the codes will have at least one or two provisions dealing with some form of or variation of pacta sunt servanda. But as Khushbu has alluded to, there is a provision in the Muqawla code of the UAE which refers to how the contractor can finish the work and place it at the employer's disposal, and therefore be able to argue that they have discharged their work, their obligations, and there is a room for the aspect of deemed handing over and a practical completion. So they are able to make that argument in UAE. There's also similar provisions in other civil codes in the GCC. Qatar has something which refers to practical handing over as such. I mean, a different translation might be virtual handing over, because it says actual or practical or actual or virtual. The new Saudi civil transactions law refers to how where the contractor completes the work and makes it ready for the employer. So yes, different civil codes have made left open the room for negotiating practical completion.
That's insightful, Adarsh. Now I come to the in-house counsel we have. Could you, Ibas, could you share some insights on the type of delays that commonly arise near a project's end? I mean, as a general counsel, you must have witnessed.
Sure, thank you, Himanshu. So it's too loud now. A little bit easier. Sorry.
Okay, let me hold like this. No, I'm fine, I can handle this. So first of all, I'm really amazed how these two gentlemen are now using their notes and speaking their minds. It's a common law practice, I believe. So we don't have that insight and trust ourselves. But anyway, thank you for the question and the introduction earlier. I'm not going to give any civil or common law background, but instead I want to give insights from my company and from an in-house legal world. Of course, the type of delay can be anything, but the contractor may suffer from financial stress, insufficient personnel, the unforeseen ground conditions, weather conditions, so on and so forth. Everything can be the reason. But in fact, one reason that I find it really critical is beyond all these concurrent delays. But to say that, I want to give a bit insight on the company I'm working at now. So I'm working at Gamma. Gamma Energy has a history of 20 years now, with 15 completed projects, operational projects on wind, hydro, and natural gas, mainly. So we have a large water conveyance project in Jordan, being the largest company in Jordan. Gamma Construction, on the other hand, which is the largest brand, has a history of 70 years now, with over 400 completed projects on railways, subways, tunnels, let me look at my notes, city hospitals, large infrastructure. So everything is within the list. This means we have a huge list of lessons learned in the company. One thing I experienced which causes an inevitable dispute in companies like us is even before the construction phase. That is to crunch the numbers and the financial model at the expense of convincing your stakeholders. So you're deliberately adjusting your numbers sometimes to convince your stakeholders. That's the biggest problem I experience. So that's highly common yet dangerous. It is at this point important to note that all investments are tied with cap budgets, but they expect good returns on these investments, and they're usually competitive. So you need to work your way around all these. And in this atmosphere, your lovely dispute journey starts, in my words. So the project team in the initial phases, or the business development team, sometimes in other companies, start working on the pricing each item, making global assumptions, and provide you with a lump sum figure, which we call as the base case model. So that's your model that you're going to present to the board, to the shareholders. Is the board convinced with this model? Definitely not. So they want some adjustments to be made. So you work your way around again, you make some contingency adjustments, and you present it again. That's base model version 2. Now that the board is convinced, you need to present it to the shareholders of your company. And in our case, we have 3 shareholders. One is the Turkish label Gamma, the other one is the Malaysian electricity company Tenaga, and the third one is the World Bank IFC. So we have 3 shareholders. And each one of them has their own interest in the company, own comments and benefits. This means immediately your numbers, your models turn into version 3, 4, and 5. And then you need to merge all these in one, and now you have version 6. And you're in the final stage of attracting the lenders, since you're not going to fund full equity, so you need to find some project finance lending. But this time, it needs to be a bit more pessimistic to attract the lenders, because otherwise you need to be forced to pay handsome installments in return to the lenders. So you revise again countless times.
at the end of the day, after months of work, you are somewhere far from ideal, far from real. So, and if somehow we are awarded this tender, then you're seriously in big trouble from day one. So you deliberately created your own dispute journey by adjusting the numbers to convince your stakeholders. That's a big, big problem. So this is what I call as the stakeholder management dilemma. This happens quite a lot. And the second dilemma that I want to mention for this question is what I call as settle now or dispute at the end type of dilemma. Or we can name is when to react as part of this dilemma. You know that every project is down to many, many little milestones. And for sure, in each milestone, there will be a discrepancy, small delays that you will face. But I think what's important is your reaction to these delays. So the question is whether you leave it till the end to allow the contractor to expedite the works, or you react immediately. I think that sets the tone for the whole project. Again, let's create a story for this case, where there's an owner, there's a turnkey EPC contractor, many back-to-back subcontracts, let's say for a large infrastructure project for 3 years, okay? Usually in the first few months, everything's great. You have your weekly meetings, nothing to report of, everyone is having happy faces. You're creating the teams, you establish document management, so it's a perfect story. But then the first silent alarm becomes obvious when one of the subcontractors starts to delay for some days, a couple of days. But you don't put much importance to this delay because you know they can expedite, it's not in the critical path, so you allow them some space and some time. But then you observe there's no improvements in that subcontractor in the following months. Then it comes to a point where you need to make a decision. Number one, you can overlook and make a verbal communication for the sake of good relations with that subcontractor. That's quite possible. Number two, you can send a warning letter reminding their obligation but not enforcing your rights. That's another option. Number three, as the milestone is delayed for several times now, you can enforce your rights. And number four, that's something harsh, but you can replace that subcontractor without waiting till the end. We have an established implementation for this question. I'm not going to say it now, but I want to hear your opinions at the end of the session in terms of your questions. But if you choose number one, which is to overlook and make verbal communication for the sake of good relations, then you're creating your own problems at the end of the project. So everything comes at once at the end, which you cannot manage. So that's a guaranteed dispute if you don't resolve at that time. So that's where we come from, and that's the type of the delays we usually face.
Communications is written, precisely.
Yeah.
So just a follow-up question. What measures do you take to mitigate legal risk associated with practical and final completion? And at what time or what point do you usually involve external legal counsel in these processes?
A simple answer is we want to involve external counsels all the time. So to be honest, like we want to guarantee ourselves because it's not a one-man show. So we want them all the time in our field. And coming back to the story that we created on when to react, if there's a silent alarm, a repetitive alarm, then that's where we want to involve the external counsel. By the way, can you hear me? It's a bit deep now, okay. So at this point, self-awareness as a soft skill is extremely important in a legal counsel. I've described this term as to be content with yourself and with what you can and cannot do. So this means you need to be aware of your boundaries and capabilities. Unfortunately, the legal ego within my colleagues and even sometimes with me, and the desire to become the hero of the story is jeopardizing the success. So this is the boundary where you don't involve the external counsels. Instead, you need to be content with yourself and get their help, at least in terms of legal opinion. Not to be fully acquainted with, but at least you can get an opinion from them. Some law firms, that's strange, approached us with some ingenious offers, and one of them offered us to prepare correspondence templates even for emails. Because this sounds crazy, yeah? So how do you even manage to generate all these correspondences? The idea is, the exercise is, of course, we didn't get by, it's super expensive, but still, the idea is to get the contract clauses on one side and to generate all these communications and to match that with potential emails and to type in advance, even if you don't use it, okay? So that sounds crazy, I know, but it's not as crazy as it sounds. Unfortunately, most of the disputes are caused by incautious legal writing skills, not by lawyers, but by engineers. I'm sorry to say, but there are many engineers I know. But the engineers, not for you, the engineers on site are so self-confident. They're typically focused on the work to do, not the writing, not the resolution. So they're business-based. So the emails can contain irrevocable mistakes at the end of the day. So it's for the lawyers to resolve, and typically not in-house lawyers, but external legal counsels. So we oversee everything, but it's good to have hands outside at the expense, of course. I also find it useful to work with the law firms at the contract phase and the pre-dispute stage, where there's still a tremendous room for negotiation with the counterparty. Somehow, we usually go for different law firms, by the way. So the ones that we're using for the contract drafting are the ones we're not using for the disputes. And there's one simple reason for that. Usually, the tendency for the contract lawyers is to protect the contract or to make interpretations in favor of that contract. So there are some blind spots in their interpretation. So this is why we're usually using a second law firm if you're ever going to dispute. So we find this exercise also useful. I'm employed by a company, so my words in a negotiation are to be taken partial by the counterparty. Of course, I'm representing the company. But once we engage an external legal counsel as a spokesperson for a company, although they're committed to act for us, it becomes useful for us to create a second layer of negotiation. I mean, sometimes it's in our best interest to hide behind an external counsel, to see the reactions of the first round of negotiations. The tone of the external counsel is more serious, more legal, more appropriate, and this leaves us a room for the executives in the company to observe the negotiations and hopefully create a settlement range. So this is surely a good side benefit of using the external counsels we use for that purpose. And finally, we're using the law firms, of course, in the dispute stage. First thing to say is that we like to give full control to the law firms, especially in arbitrations where there are multiple tasks. But in return, we want to hold them fully accountable, fully. This means we don't like loads of recommendations, okay? So we don't like many assumptions, many caveats, many options. We want clear guidance, maximum of 2 options, and a roadmap. So if the case requires a technical expert, a quantum expert, we expect the law firm to bring one name only, and we get to decide in terms of budgets. If it's not suitable for the budget, then we can proceed with the next option. Otherwise, we don't like to read CVs. We can't read all their prior articles. It's like a turnkey law contract for the law firm to handle. The same goes for the arbitrators. We don't like to read their CVs. The moral of the story is to skip all these phases as soon as possible with the help of the external counsels.
We have
It's a huge pressure, yeah, no, yes.
We move forward. So we'll touch upon some contract specific questions also, FIDIC specifically, although you have touched upon it briefly. FIDIC contract usually specifies definition like taking over and defect notification period. How do these align with the concepts of practical and final completion? James?
Well, I think is that okay now? Well, as you said, I touched on before, I mean, in some respects, the same issues come up again, but against the lens of the FIDIC approach. FIDIC, particularly red books used here an awful lot, 87 and 99. The idea of completion in the FIDIC terms, so clause 8.2 effectively tells you what you need to do is to achieve test and completion, and anything else in the contract that is required. And that, in a sense, is a reflection of what Julian was saying earlier on. Well, FIDIC adds sort of within the standard terms itself a particular layer, which is achieving test on completion, which is a particular approach to how you define whether a building is usable or not. And actually, the important thing is, in this region, as much as you elsewhere in the world, is looking elsewhere in the contract to understand what it is the parties negotiated as being the additional requirements beyond just test on completion as defined by specs. And in my experience of this region and looking at FIDIC elsewhere in the world, is that that's the key problem. It's the one that Julian mentioned earlier on, which is working out whether or not you've got sufficiently far down the list of things that are set out, sometimes really quite reasonably set out, and the long list of documents that are required and requirements you must meet before completion is capable of being certified, and deciding whether you have achieved enough of those in content, enough of that list. So in that sense, the FIDIC is no different. It just simply treats practical completion as being takeover, that's the word, or completion, and you have to achieve the tests on completion you agreed to achieve, and whatever else you put into the contract as being defining the criteria by which the certifier will give you your certificate of takeover.
Okay. I think I have a follow-up question to Julian. Julian, how critical is the certificate of practical completion in FIDIC contract for closing out the project?
Well, it's very important for contractor and employer alike. But of course, the big issue often is one of whether the certificate is due, whether it should be issued. And we need to recognize the factors that can influence that. Not only the physical state of the works, but, and I'm now focusing on the GCC at the moment, and perhaps other parts of the world, there can be other influences on engineers, on certifiers, in deciding whether to issue a taking over certificate or not, and that can be often the client's preference. The client might have decided, I don't like the work the contractor's done here, I'm not happy with the contractor, don't give the contractor this bit of paper, I want to claim delay damages. And then in that situation, which does arise, the engineer faces a difficulty because the engineer has to make a call and say, well, actually, either the works are complete in accordance with the contract, I have to issue this certificate, and that is the appropriate way to go. Or the engineer has to cave into the employer's request, and then the engineer potentially faces a difficulty later on if there's an arbitration. The question is asked of the engineer, why didn't you issue taking over certificate?
I think I want to move on to the expert now. From your perspective, Mayank, how does the snagging process, which is sometimes a very lengthy process, and rectifying minor defects impact the declaration of practical completion?
Yes, so as an expert, I would like to throw light on two things, basically. First of all, one needs to understand that the minor defect, if a contractor has declared a practical completion, and there are only minor defects which can be actually corrected during the defect liability period, that's fine. But when there is a dispute where the contractor has claimed a practical completion, but the employer is saying, no, the defects are not minor, and they are affecting the intended use of the project, then we are at a problem. So if the minor defects or snagging process is not taken up properly, the biggest problem a contractor faces is the extension of time issues. So the contractor has claimed practical completion, employer is not agreeing to it, so you don't know what is the end date of the project, so you don't know till what time extension is to be claimed. That's one part. The second part is the quantum claims related to the extension of time. So definitely the extension of time is going beyond what contractor has planned for because he's not rectified minor defects and they're not properly rectified. So you don't know whether the delays beyond that are excusable, compensable, and so on. So then the quantum comes into picture that, okay, whether you can claim cost, time-related cost or task-related cost of those claims. So these are the two major claims which basically come in picture when you see there is a disagreement on practical completion or minor defects are not rectified properly. Secondly, there are other things as well which come into picture, like it will affect retention and final payment. So since the project is not completed, your retention will not be paid, you cannot claim the final payment. So then there are losses. Then of course, if it is established that defects are not rectified properly, then there is a cost related to which already the lawyers on my right has explained that there is a cost of rectifying these defects. And then comes the Pandora box of claims and disputes and which goes on. Tagging is done properly, then we can avoid all such things, though I have not seen being avoided a lot, but okay, we can avoid all these things. So this is what I have to say in short.
Just a follow-up question.
Yeah.
What actions should the contractor take to secure BGs, pending payment, and other entitlements?
So definitely, when project completion is at stake, BGs are at stake, final payment, retention, everything is at stake. So what action should contractor take? So the contractor should not take any action at the back end of the project while rectifying minor defects of the. It's a process, and it's a process that is to be followed in the course of the project. So the contractor should review contract terms properly, understand its obligation, and be fair to them. Then submit payment applications and all contractual applications and notices on time. Do not delay them. And then, yes, addressing minor defects while they occur. Don't wait for end of the project. Address all those defects while they occur. Again, write letters, emails, prepare documentation. So definitely, I was sitting with a renowned retired judge, and he asked me that while you were getting married, did you think about divorce? No. So while we are executing this, while we are executing or entering into the contract, we don't think about dispute, but do think about it. Do think about disputes may occur. So track and comply everything that is written into the contract, and try to resolve issues before they become disputes. So when they're minor issues, these to be shown. And again, as I said, maintain communication and do the addressing of minor defects when they occur. So this is the major takeaway.
Adarsh, would you like to add something to this question?
Just a few small aspects. I think as a contractor, if you want to indicate that your work is complete by a certain date, then you need to document that by clearly requesting for issuance of a provisional acceptance or partial acceptance or sectional acceptance certificate, so that you can at least put a date to that claim in writing and provide evidence that the work meets the criteria set out under the contract, the specifications set out in the contract. And of course, some contracts require you to also give certain additional information, whether it's as-built data, as-built drawings, inspection reports, tests. I've seen contracts which require you to do O&M manuals, carry out training of the personnel. Yes, the other things I agree with Mayank. You need to make sure everything is in order from a monetary perspective. Raise all the invoices. Make sure the retention is reduced. Make sure your BGs are sometimes reduced or returned, PGs or bonds, whatever. And it's important that your payment applications also cover all items that are invoiceable. I mean, if you leave items that are clearly supposed to be invoiced later, you're not indicating that you're complete. So from a balance work perspective, if there are snags, I would only advise you to also document the rectification process so that you can invite the employer to inspect the work again and make sure that the snags are or punch lists are complete, and then you can formally request for a final acceptance certificate.
That marks the end of our segment 1. The mic is not working. Yeah, it's working. Thank you. So I start with segment 2. It's a small case study. There may be some answers which may be repetitive, but please bear with us. It's an important issue. So let's consider a scenario, a large road project nearing its completion. The road is in use, but not complete to specification. Most of the works are complete, but minor completion, i.e. street lights, line markings, etc. are not complete or partly complete, and snagging remains. The contractor asserts practical completion has been achieved and seeks an EOT due to delays beyond its control. Up to the date, it asserts the road was completed and taken to use. Now the employer position is that it denies the works are complete and is withholding payments, citing LDs. Let's understand from the panelist, how should the parties approach the dispute, both from common law, civil law, contractual perspectives, everything. So I start with Julian Yu. Under common law principles, how would you advise the contractor and the employer in this very situation to approach the claims that the works have achieved practical completion and for an extension of them?
Well, I think in relation to the issue of completion, practical completion, again, one has to go to the contract. What does the contract say about when practical completion is achieved? Is it enough that the road is built and there are cars and trucks driving along it? Or does the road have to be built and all the street lights are installed and the lights are on and the lines are painted on the road and everything is there? And we need to look at the contract. And the contract could say a lot or it could say very little about what practical completion means in that situation. I think that the scenario we're looking at there actually poses a common situation and also a kind of legal dilemma in a way, because on the one hand, the employer is probably getting the benefit of the roads being used, but on the other hand, if practical completion of the road hasn't been achieved, then the employer can claim delay damages because the road has not achieved practical completion. So the question is really how can this work in that situation, or can it work? And as a matter of common law, it can. It would be possible for an employer to claim liquidated damages during a period when the product, the road, the building, the factory, whatever, is actually in use. That would be permissible. But then coming to the extension of time question, that's really where the contractor would need to set out its position quite clearly. First of all, it would have to say either practical completion has been achieved on the relevant date, or if not, then the contractor is entitled to an extension of time for whatever reason, some kind of employer delay or excusable delay.
James, would you like to add something?
Well, I think moving forward, I'll sit back. I think the point from my perspective to emphasise is one that's been made almost by every one of us is recording, keeping records, making sure that at each stage, from the point in time at which the practice perspective, you're of the view that there's a problem in the sense that what you think has occurred contractually is not being recognised by the employer, and there's a potential dispute, recording. Should have been recording actually for a lot longer. I spent a lot of my life giving talks to contractors about what needs to be done when managing contracts. And the key point in this region is making sure notices are given at all times. And you do find contractors who are worried about setting off on the wrong foot early in the contract with the employer by coming across as aggressive and overly contractual when giving notices. And actually, the point is, unless you give notices, I think as you were saying, you do not have a chance to come back later on. Same is true at this point in time we're talking about in this example. There is no such thing as being overly contractual in that scenario. If you are in dispute or about to be in dispute, you need to make sure that you have prepared and protected yourself as well as possible, which means recording. It means recording not just in the formalistic sense of producing the documents that are required by the contract. It means getting out a camera or a phone and and taking pictures of the road with cars on it, and showing pictures of where you got to, properly recording progress in all sorts of ways, that ultimately, if you are going to be interviewed in front of a tribunal 4 years later who don't know the road and didn't go to the road at that point in time, you can express in a way which they will understand and appreciate what it is was presented to the parties at that point in time. So recording of the contract, recording any other way you can. In terms of Julian's last point about extension of time, yeah, the difficulty with, of course, the contractor is trying to do two different things, both saying I'm finished and therefore LD liabilities end, but if I'm wrong, then I'm entitled to extension of time so to avoid the liabilities. In that respect, I think we have to space up the fact you are presenting two faces effectively and do both properly. Because at the end of the day, somebody else will tell you whether you're right or wrong about having achieved completion. And if you're wrong about that, you want to make sure you haven't missed the opportunity to make your claim in extension time. And then again, I think as we've both said, but others have said in their own way about other systems, as we all know, as contracting infrastructure projects become more mature in various parts of the globe, GCC particularly, there are increasingly complicated and limiting requirements as to how one can put forward extension time claims, requirements as to how you program and plan, progress report, express your claims. And those two must be followed. It seems to me always not quite the sort of matter this talk. You need to be following those obligations as well.
Ibars, how do you manage the risk of LDs in this situation? Specifically, if we talk about civil law, we have got the answers from a common law.
Sure, I don't have any answers from common law, but we don't manage the risk. Actually, we live. So if there's an LD to be paid, we pay. As I said, straightforward answer. But of course, the LD becomes due and payable, as we call it, in the final completion date, or the practical, as we say in this panel, where the works are supposed to be completed in full. Most probably in your scenario, in a large road project like this, there should be thousands, 10,000s of pages of contracts and attachments and reports. And in somewhere, there needs to be a proper definition, as Julian mentions as well. So we need to look into that definition. And there needs to be a reference to the minor issues list, minor discrepancies, these lists where the discretion is usually with the owner to identify these minor issues at the end of the day. I'm not sure the street lights or the line markings can be suitable to be said as minor issues, but that totally depends on the definition, of course. But let me give one example from my story from the company that I'm working now. So in Jordan, we have a large water conveyance project. And the whole exercise, the construction was to drill 60 wells and build a pipeline of 350 kilometers across Jordan. So that was a huge project. And at the end of the day, in the scheduled final completion date, we built the whole pipeline, 350K, but we only drilled half of the wells due to many reasons. So there was only 30 wells drilled, and the remaining 30 was still waiting its time to come. This means we were still able to deliver some portion of water, not in full, but partially. So we created interim periods of water delivery for that project. Surprisingly, no LDs were imposed on us at that time, as we agreed to undertake to upgrade one section in that project. So LDs are there usually hanging in the project to discipline the contractor or the owner. So they're not usually, or they're not ideally enforced. That's there to discipline. And they're treated like a financial commodity at the end of the day and can be subject of a give and take easily. So I'm not going to enforce your LDs, but in return, I expect you to upgrade this section. That's an easy scenario for us to deal with. Even if you were forced to pay LDs, I can assure you, it's always in the financial models in the project budget as contingency. So a contractor is usually not afraid of paying LDs if, to a certain point, of course. So in a couple of months, you can pay LDs. It's a loss of your financial income, but again, it's budgeted usually. So it's quite easy to manage the LDs at the end of the day by exchanging with other works to do. It's usually my experience.
Insightful. Khushbu, this question is to you. How does the concept of good faith influence the employer's ability to withhold payments at this stage for this very case?
Okay, so maybe the right way to look at this question is if I was, or whenever I sit as arbitrator and good faith arguments are a focal part of the party's submissions, I already know that's a really strong indication for me that that party's position isn't very strong because it's good faith. It's not a standalone obligation even under civil code. It's there. It's enshrined. It's a provision we all use, of course. But practically speaking, the impact or the effect of good faith is actually the same, whether it's civil law or common law. So good faith is a lens through which the parties' contractual obligations need to be interpreted. I might sidestep your question a little bit because the perennial debate in this region, or actually I'd say the whole construction industry, is whether it's common law or civil law that's more beneficial to a party's rights. And surprisingly or unsurprisingly, the answer is that it really makes very little difference. And we had a case where we did this huge study for one of our clients as to what laws would be more beneficial to them for their claims. And really, the answer was that whether it's English laws or whether it was Qatari law in that case, it meant very little difference to the impact. But one of the nuances between civil and common law is actually when it comes to pay when paid or pay as paid provision. So if that's in your case study, if there's a binding provision which says that a contractor doesn't get paid unless they are paid from the employer side, then that's when the situation is a little bit different between common and civil law because the position under common law is a lot more clearer that these clauses are unenforceable. But under the civil code, it's not that clear. I mean, we have made successful arguments that these clauses are unenforceable, but the position really isn't clear. And I think that's really one of the, I'd say, beauties or pains of the civil code where it's very fact centric. So you could use arguments to envelope it the way you wanted to position your case. But the simple, I would say, position would be under civil code. Technically speaking, if there's a pay when paid or pay if paid provision, it is binding. But we come up with all sorts of creative arguments to find a way to stop them, and we have been successful in many arbitrations.
Adarsh, would you like to add something on the good faith?
Just that good faith is generally a spectrum. It's not a standalone obligation, as Kush was mentioned, and it's difficult to be used as a sword or a shield. So it's really you're really grasping at straws if you're having to use it as a standalone breach claim. While parties may have different interpretations of what good faith constitutes, it really depends on, in such cases, what's your primary argument going to be, and if you can bolster it later by saying good faith. Like if for example, in this case, I would say that the street lights are compromising the safety of the users of the road. I can then also say good faith. Or if I can say that the road markings are disabling the proper traffic from being followed, and that's also compromising safety, amongst other things. So again, these are all breach of contractual terms, which you can supplement by saying should not be done as per good faith as well.
Insightful. This is the last question, and then there is one common question for all the panelists, but this is for Mayank. Mayank, how would you undertake a critical path assessment at this stage of the project when only snagging items are the remaining bits?
So, critical path assessment can provide a lot of insights. First of all, as a data expert, what I would do in such case, actually, I have been through a very similar situation, not on a road project, but on other linear projects like radios. So what we are required to do, first of all, we need to have the latest update of the schedule, and we need to find out what is the critical path at this point of time. While assessing the critical path, we need to focus on snagging items, whether this critical path is passing through those snagging items at all. And if yes, so what is the remaining activity? What is the remaining part of that snagging item? What is the remaining activity? That becomes very important. And once we have come out with what are the remaining activities. So what are the time estimates that we need to find out the estimate of time in which this particular remaining activity will finish. Once we have found it out, we have to go further deeper and find out what are the delays that are impacting the completion of these snagging items. See, I'm not getting into the legal fact because that's not my forte, whether it is put into intended use and all those things. I'm only telling you whether it is critical or not, the completion of the project, not the usage of the. So again, why it is critical? Does it has any float or not? And what are the reasons of these delays? Now, once we have established the reasons of these delays and the attributability of the delays to the parties, which of the parties, either of the parties, then contractor can build a case of extension of time. If these delays in snagging items are on critical path and are causing delays, and there is a specific reason of extension of time which is not attributable to the or beyond the reasonable control of the contractor. So of course, there are so many supportings that would be required to put forward these claims, but this is how a critical path assessment of this entire snagging items can help a contractor to build a case.
Maybe the long snagging bits should be more focused.
Yes, yes.
This the last question, and then we can have some questions from the audience also. So this for all the panelists. Maybe we'll start from the extreme right. Yeah, right. Sorry. Yeah. So what one-liner advice would each of you offer to contractors and employers to ensure that both practical and final completion are achieved smoothly, minimizing disputes and legal risk?
Since you're saying one-liner,
Yeah, it's a one.
yeah, exactly. I suggest to use experts and counsel and consultants all the time. One-liner. Yeah.
James?
One line. Do it properly. Do the work properly. Follow the contract. Notices, records throughout.
Yeah, I'd say it's a question of definition. Defining what the finishing line is. So often in contracts we don't do it, and for the employer and the contractor to define this is what practical completion is, this is what final completion is. You can take out the scope for argument over those issues.
Oh, this is difficult, but maybe I'd say just get it on the record early. Just put it on the correspondence, issue to the other side, so that you can use that piece of correspondence or letter probably years and many, many years after in the arbitration, use that data that's in the correspondence. So just get it on the record.
Adarsh?
I'd say follow the contract and refer to the contract and the correct clauses all the time.
Mayank?
Yeah, so I agree to all the experts on my right. I would say additionally on the one line, hire Mason during calls so that we can help you.
So I would want to have some questions from the audience. We have a lot of time left. And just introduce yourself and you can shoot.
Sure. Amin Camus, managing partner, Charles Russell Speechless. Do we have a mic? Or
Yeah.
Thanks very much. Aline Camus, partner at Charles Russell Speechless. One of my questions was, it's not uncommon in this part of the world to have a contract, but then to have a series of supplemental agreements that follow. Oftentimes you can see one, which is you can deal with, and sometimes I've had a matter where we got up to supplementary agreement number 8. The difficulty, I think, arises on these sorts of projects where practical completion may well be defined, but it doesn't account for supplementary agreements that follow. Now, in the context of them not speaking to each other, disputes can and do arise. I suppose my question is that unavoidable to some degree? If the contract's been drafted poorly or no one's given thought to it, or is there a way to mitigate a situation that arises in that situation?
Your question is to
The entire panel.
Yeah.
Yeah. Thank you very much.
Well, I think in the scenario you've described, where you have a contract and then a number of supplemental agreements, in a sense, the outcome is a function of what the parties do or don't do. So each moment that they are agreeing to these amendments, someone has to have in their mind, well, what is the impact going to be when the day comes and the contract says, I've reached practical completion. Will the employer be able to turn around and say, well, hang on, look at amendment number 6, which says that, which changes the idea of practical completion.
Yeah.
It could be that. So I think that there's no silver bullet in that situation. It's just the parties being cognizant of those issues when they're going through these supplemental agreements.
It's those gaps that arise though, because people haven't given thought
Yes.
to those sorts of definitions. And I don't think there may well be an answer in circumstances where you have a contractual definition of practical completion, but it's only been defined for the purposes of that contract, the main contract, not necessarily the supplemental agreements which provide for additional work.
Yes, but even in that situation, I mean, with supplemental agreements or deeds of variation, whatever they're called, there's usually an interfacing clause in the later agreement saying whether the terms of the supplementary agreements override in some way, whether there's a conflict with the primary agreement or vice versa. But that might be a way of doing it.
Right, I'll go back in terms of the example you've given of supplementals experience. I recognise the point. In my experience, is generally what we're talking about is some type of formalised version of variation agreement. So what we vary in the scope and nature of the works. And it's clearly conceptually possible that something you've done in the original contract which defines extremely closely what completion is because you have to do a particular test, for example, becomes OTOs or is inappropriate to whatever the works have become. I think during to that point, what you've got to do is you've got to test whether or not the final agreed scope is capable of meeting that particular definition. I've not come across a situation where the parties have gone back specifically and tried to change the practical completion definition itself. And you're right, so you can end up in a situation of conflict. I suppose as you're both saying, what you need to have done is if it is the case that by changing content, work content or work quality, you've made a particular test of completion or a particular performance guarantee possible to achieve, you need to have spotted that and dealt with it, because you are going to have to grapple with the question, do I need to change item number 25 in my list of practical completion tests? Thank you.
Hi, I'm Rama and I work for Mace. Whole my life I've been working on road projects, so it's interesting that you took that example. While there is the principle that what you write in a contract, the word of the contract and the interpretation of contract should be appropriate to the project and the condition. Taking over of a road, especially in a place like the UK where the roads are quite established and most of the projects are generally widening of an existing road. Expecting employer not to use a road which you have already built, even without the marking or without the street lighting, that's just common sense. If you have pre-qualified for working on a road project, you know that somebody is going to use that. If nobody is going to use that, you are going to use it for your construction vehicle movement. So deterioration of the road and all these things are, as an after effect. What I would like to know is when it comes to the interpretation of the taking over in parts clause of any version you take it, especially the legal perspective, it says, of course, the contract says that if employer is using it, then it is supposed to be taken over. But that doesn't mean that you've completed the works. But how do you think can a contractor who has been working on road projects for years, a very similar project with a very similar employer in the very similar city, how would they be able to establish a claim? And can even the usage of this become a causation for any other after effects? Any damages that they cause, any reworks that they will lead to? Can a contractor say that, no, you're not supposed to use this, or I was not aware that you're going to use this? Because he is aware, everybody knows that. And sorry, but any infrastructure contractors here, please don't hate me for saying this.
If you could have some thoughts on the question, which is a relatively common one. I think what tends to happen, and whether it's a road project or a building or anything else, if the employer has actually taken over the subject matter, the road, the building, the power plant, and is using it, that tends to provide fairly strong forensic and persuasive weight to the contractor's argument. I've achieved practical completion. Look, the employer's using it. So that's a fairly compelling point. But the situations we're considering, and the one in the example, is one where there is that grey area, that ambiguity, where certain things, maybe not everything has been done that needs to be done. And what this sometimes leads to, so now stepping slightly away from your question a bit, is another problem, which I'm sure many people here have seen. It's where the engineer, the certifier, perhaps recognizes that not everything has been done that needs to be done for practical completion, but the employer can use the road, the power station, whatever, and is using it. And what the engineer will then do is issue a certificate saying practical completion has been achieved, subject to, see this, well, not what we call a snagging list, a list of things. And if you look at the list of things that need doing, some of them might be snagging, other things might be more substantial, and actually things that needed to be done in order to achieve practical completion. And that then brings into question, well, if the engineer issued a certificate saying practical completion has been achieved, subject to the following things being done later on, what status does that have under the contract? Is this a valid certificate issued by the engineer? Because if it wasn't a valid certificate, then delay damages could keep running because the practical completion wasn't validly certified.
So if I could just add something. So if the employer has already possessed the property, that's an easy one, right? You can always argue that he's using it because it's already fit for purpose. But sometimes what's more tricky is if he hasn't yet occupied it, and the argument really is he should have been able to. So you want to stop any bleeding of potential claims. I mean, again, it's a very fact-centric argument, but comes up quite a lot in disputes. And what we usually do, again, is rely on the site investigation reports, or it could be the weekly or daily reports to show that the amount of works, the percentage that was left is very minimum, or sometimes it's actually already completed, and prove to the tribunal what's actually left or outstanding wouldn't have affected the actual possession of the property. So again, we use expert reports, we use witness statements. There's all sorts of ways we can achieve the argument they should have been able to complete, and that's a little bit more tricky if they haven't, but they could have. But it comes up quite a lot. Again, it comes back to the reports, it comes back to the records on the site that we use to prove that.
I just have one more thing to add here.
Please go.
So I just had one more thing to add here about your second part of your question, because you did allude to a scenario where the contractor may have not expected for the work to be utilized, and you said that the damage, there might be damage to the road. Yeah. So in that scenario, it's going to be difficult for you to say that I'm going to absolve myself of any liability if you use the road and there's damage caused to it. And at the same time, you're saying there's practical completion, you're also using the road. So here, there's of course what you had referred to. You could say sectional completion, and for parts of the road that you say that is being used is defect free and there are no snags or any defects whatsoever, you can say give me sectional completion for that. It's really important for a lot of contractors because they really need some certificates to be able to. Even a partial completion is really important for some contractors, not just from a monetary perspective, but to use as part of their next bid. You know, I have done a contract in the UK for this particular time, so I have achieved partial completion. The second aspect to your question is that if you're intending to absolve liability from any defects, you should also clearly put that across, because the difficulty there is that if the road is going to be utilized, you're also going to be asking the employer to give the road for you to be able to rectify those defects. And if the road is already being used by the general public, then is he going to give you a certain point of time, and he's going to hold the traffic and allow you to rectify the defects? Or is that going to be a cause for concern for you to be able to raise a whole host of claims later?
Okay, quickly. So we had this case in other projects where we were the owners and we issued the final completion certificate with conditions saying that these are the major discrepancy lists that we identified. the immediate effect of that was to cut the LDs. Normal LDs were imposed, but the defect liability period was extended until we were fully satisfied with the rectification. So I think that's a midway solution. Otherwise, do it or not. So you don't allow for them to use as a contractor, but if you use normal LD, so that's a good solution for both ways, I believe.
Add on to that, what we normally have done in this market usually does is approach the employer to get a certificate to just replace the retention amount by bank guarantees, to get the cash flow running during the DLP period so that it gets within the cash flow of the project it's managed.
Yeah, that makes sense as well.
One of the things that interests me about your question, that was, I think, a really difficult one, is the point you made on the example you gave of lane widening or road widening, which actually is not not really what we've been focusing on, which is I think underlying all the discussion we've been having is the concept of a new bit, new design, new build, complete. You can define completion, and then you at least in principle, work out when you complete and move on. Although you may dispute it. I think the difficulty that's encapsulated in the example you gave of road widening is the sort of concept of existing asset changed, refurbished, adjusted, repowering a power station or additional hersings or whatever power station. You want to operate your asset throughout as part of the process of adding on some functionality, a new lane, a new hersing, or what it happens to be. You've got to power down or take out of action a particular lane. And the problem there, I think, is I don't think that the concept of practical completion or completion that we have been discussing really works for those scenarios at all. You think of it start from the very beginning and say to yourself, well, that's not going to work that way because, as you pointed out, you'll lane shift at certain points in time away from onto the hard shoulder, off the hard shoulder, where it happens to be, or you'll power down turbine 3, or what it happens to be. And you've got to just think about that in advance and define that in advance. And you may use the words completion, but they're not quite the same things we've been discussing, I think, because you're at that point dealing with a much more coordination, cooperation type scenario in which both parties have obligations to do and not do things that may impact the process or workflows. Really interesting and really difficult, I think.
I have had my company asking me to do the claims based on the wording in the bidding that if employer uses it, it's deemed to be taken over. And I said, no, you can't do that. So,
yeah.
One last question.
Yeah.
Or two will take two.
Yeah, hi. My name is Samir Khan. I'm a founder of SA Legal. And we tend to do quite a lot of work in local courts, construction cases. And what we've found is that the local court experts, as a rule of thumb, what they use is the building completion certificate issued by the Dubai municipality for buildings and construction. So they don't usually go too much in depth about the factual, or was it really, can you use that building or can you not use that building? Is that building being used? They take the date of the issuance of building completion certificate. Now, do you think that that is something that the arbitrators could use as well? If they're thinking that if that's the approach that the local courts are applying, then maybe that's makes it a lot simpler process for the arbitrators.
Yeah, I'll take that one. So I've met several contractors who show me or really emphasize the fact that they've received a building completion certificate from the municipality to be able to say that, okay, why is he not paying my retention? Why is he not returning my bonds? Why is he holding my payments? But unfortunately, if those contracts are governed by the GCC laws and it stipulates arbitration, the tribunals are going to look at the terms of the contract and not necessarily going to be look at what the municipality laws or what's going to enable the end user to be able to use the building. So they're still going to look at what are the definitions of final completion when the contractor has sought for final completion, when the contractor has called for the employer or the engineer to do the inspection, rectify the defects, call for final inspection, and then raise the invoices, and so that everything will have to follow the contract's mandate nevertheless.
Can I say, consistent with that answer, which I completely agree. I think we're looking at two different things. On the one hand, you have the local construction codes, and the local authority or the inspector will be considering those and sign off or reject, or according to whether the code is complied with. And usually, if we look, I presume here, and in many other countries, that is to do with the habitability of, if it's an apartment or a house, is it okay for someone to live in this place? That's usually the question from a regulator's perspective. But that's not the same thing if we're looking at a construction contract to build a house or an apartment, because it might say, for example, well, the walls have to be painted white. If the walls are painted brown, then the person who's paying, the contractor, can say this hasn't been done according to the contract. Now, it might be quite okay to live in the house, whatever the colour of the wall is, and the local inspector may have signed it off. If the contract says it's got to be a wall of a certain colour, or whatever it is, the taps have to be gold in the bathroom, that sort of thing. That's what needs to happen in order for practical completion, final completion to be achieved.
So maybe Julian referred to it very implicitly in his answer, but I think the underlying court system just isn't very satisfactory for construction disputes. And I can say this because my firm does both construction litigation and arbitration, and some very complex, high-value ones, and we see it in both forums. And I think the reality is that the court experts are just not equipped and not technical enough to deal with it, and that's why you have a situation where they're looking at some of these building certificates because they're just not doing a deep dive into the contractual mechanism. So I don't think it's a satisfactory answer. I think it's a quick solution which they offer, and I think the system needs a fix. So definitely we can't adopt the court system to arbitration, but it's obviously the court system that needs to be fixed, not the other way around.
So I'm Joanna Lamar. I'm a district engineer. I work for Allied Software. So my question is related to the substantial or practical completion of the project and the contractual completion of the project. So actually we've encountered several disputes where the employer will say, no, you haven't completed the contractual work, then I will not issue the TOC for you. Whereas on the other hand, the contractor will say, no, I've completed the substantial work, and I can complete the remaining or the pending work or rectify the defective work after the TOC during the DNP, just to an attempt to absorb liability from paying liquidated damages. So what would be the criteria to determine whether the defective works are qualified as snags that can be rectified after the TOC, or no, they are works that should be completed before the TOC is issued? Because sometimes we've seen some BCC that has been issued by the DDA, the Dubai Development Authority, where it contained several comments. So sometimes the DDA will issue the BCC, although with some comments, and here the dispute will be whether those comments are snags or will prevent the employer from issuing the TOC or not. And some other times we see that the DDA will not issue the BCC, although the comments are less significant. So what would be the criteria to determine these two? Because this is a key issue to determine whether the contractor will be entitled to extension of time or not.
So my understanding of the Dubai building completion certificate process is, as we were discussing earlier, it's a regulatory process, but it is a factor that dictates whether or not one can use the building. So when we look at that direction, if you can't get a BCC, you can't use the building. That would rather tell you that whatever the comments were, the reasons for the BCC certified to refuse the certificate, you haven't got that completion. However, the student says, if you've got the BCC, it doesn't mean you have issued that completion. It's the other way around in a sense. That question, I think, as we obviously the systems a bit differently from the English law perspective. It's common law perspective. It's you're looking for not necessarily the complete removal of patent defects, but any defects that need to be. The most recent word used by English law is trifling, not things that affect the beneficial use of the building for which it is intended to be used. that becomes a very fact-specific question that the tribunal needs to think about. What is the building you bought? So taking Julie's example of a high-end, gold-tacked apartment in a building, it's not capable of being used for the benefit of clients' boards when you have standard stainless steel faucets on taps in the sinks. Different is a warehouse, often just a city somewhere, where basically what you bought is a shed in which to store stuff, and you've got racks and the like in there, you've got a fire system in there, you've got lighting in there, you've got doors that lock, but you haven't necessarily got the most up-to-date building management system which sends the lights on at a certain time of the night, if that's what you want. So you've got to ask yourself the question, I think, at each time, what is this building there for? What have I bought? If there are things that aren't quite right with it, do they affect, given the nature of what I bought, do they affect my beneficial use? The BCC is an aspect of that, it doesn't prevent you getting classification. I don't think it's the right, so the reasons are given that wrong.
I can comment on that as well, by the way. So we don't have anything under Turkish law, pretty much civil law, where we get the roots of that law from Swiss law, by the way, as substantial completion. But what we have in the court rulings, high court rulings, is in one of the rulings, if 90% of that construction is completed, then the contractor needs to be compensated. So that's at least useful to understand that although you cannot achieve practical completion or full completion, still you have a way to be compensated by all the work pro rata or proportion to your completion. But this doesn't mean that you can claim to be issued a certificate. It's the actual completion rate that goes along with the compensation level, that's all. Other than that, the story continues until the full completion.
Well, that concludes the event. Thank you everyone for being here.
Thank you.
I think there are drinks and let's go.